Okay, welcome everybody to the Vocational Science Freedom Civics and Sovereignty class held on Saturday nights at 7 p.m. Central Standard Time. And tonight we'll be covering the Grand Jury, which we've been covering for the past several nights. And the Grand Jury links are in Class 6 Docs and Links, and you can download them from Mega Folder. I also put the Mega Folder link into the classroom. And the document that we've been covering for the past several weeks has been a civil grand jury manual from California. And it's the first thing in the folder. So you'll be able to see one civil grand jury manual, 1999-2000. That's what we'll be reading from. And then later on tonight, I think I'll cover a letter that a grand jury foreman wrote to a judge, because there's some interesting language in it as to how annoyed the foreman was about the goings on and other various things that happened during his time as the foreman of that grand jury. So, as I said, this is the California Grand Jury Manual, and we left off under Chapter 3, under Powers and Duties of Grand Jury, and we left off on page 83, and we went through the inquiry as to what the grand jury can look into as far as prisons. So let's move on to page 84. Investigation of ownership, transfer, or sale of realty subject to a sheet. Order directing institution of proceedings. So now I covered what a sheet was last time, so I'm not going to go over that ad nauseum, but very shortly, when something is sheets, it's when someone does not have a will and no heirs are to be found. And so that man or woman's lands and estate then a sheet to the state. But since we the people are the sovereignty of the state, what happens is that there's an estate sale. And that's exactly what this is talking about. From the standpoint that the whole entire system, this whole entire slavery system, through registration of property, pledging, debts, bonds that are placed on our birth certificates, at fidelity, all of this all has to do with the corruption of probate law and the numerous presumptions, which are over every single one of us as an American, and some of them right at birth, from the registration of the birth and the signing of the birth certificate contract, which is basically a pledge, which pledges the child to the state, and then when no one comes back to claim the child's estate, or when the child grows up and comes of full age and fails to do it, then basically what happens is that our estates they've all been escheated, if you will, to the corporate state. It's under a different pretense. It's a presumption that exists. And then when someone does actually die, they'll end up going through these proceedings if they do not have a will and they don't have an heir. So let's get into this here. So the grand jury may investigate and inquire into all sales and transfers of land. Notice that says land, not property, because property is what sits on top of the land. Land is the land itself. And into the ownership of land, which, under the state laws, might or should escheat to the state of California. For this purpose, the grand jury may summon witnesses before it and examine them and the records. The grand jury shall direct that proper escheat proceedings be commenced when, in the opinion of the grand jury, the evidence justifies such proceedings. Amended by statutes 1976. So when you think about what they just said there, that the grand jury can investigate into lands that, in the opinion of the grand jury, justifies a proceeding regarding an escheat. Okay, then what would be the opposite of that? What the opposite of that would be the grand jury's ability to look into how or why, well, the who, what, when, where, and why, the grammar, logic, and rhetoric of what this system is, to demand to know how we as Americans are being turned into bonded debt slaves, how we as Americans are having our estates administered, particularly since 1933 with the New Deal, and investigate into and collect all of the proper ways to reverse engineer everything that they've done. Now, at the Vocational Science of Freedom, the status doc set that we've created does a vast majority of that. However, I wish to eventually have organized in each county, if possible, that we have 25 people who have done their doc set in each county and then form a grand jury for this specific purpose to completely investigate, overhaul, subpoena, find out, learn, and lock down once and for all exactly what these corporate municipalities and the corporate state in general is doing regarding our estates, and then how to do what would be the opposite of this. Instead of having an escheat proceeding where the proceeding is to transfer the land and ownership of land from the one who had no will to the state, and instead just reverse this. Say, hey, we have a lodial title. We hold our lands in allodium, and there's nothing higher than title in allodium. It means you have no higher landlord. And in Wisconsin's original constitution, and someone mentioned to me that Oregon also said this, but I haven't investigated that yet, that in Wisconsin, at least it says that in Wisconsin, all lands are allodial and feudal tenures are prohibited. Okay, what's a feudal tenure? It's an aspect of having a landlord of which you pay a tax to, of which you owe them a duty. That's feudalism, to pay homage to your lord, and right. And it's always been interesting to me that the name of the company that holds the bonds on our birth certificates, the name of the company is Fidelity. I've always found that to be an interesting connection there. It's almost like they're laughing at us to say, ha ha ha, yes, you all owe fealty to these corporations, these corporate states, or to a corporate municipality in some way, shape, or form, because you haven't come forward, claimed your estate, and proclaimed your sovereignty outside of the force, fraud, lies, and coercion, the pledges, the registrations that bind us to their law merchant system and bind us to maritime admiralty law in ways that we don't even know it's happening. So I just wanted to bring that up because I mentioned this before, but I had a discussion with a gentleman today specifically about this issue, and he was very interested in getting the rest of his people together, and so that we could form a grand jury and to start to write all of this down. Now, of course, everything that I just said about learning what is going on in their system, it is going to be a lot more detailed, obviously, than what I just said. But the point is that you get organized, you start writing down questions. You got to start somewhere. So you start writing down, and I can give you a very long laundry list of where to start. But you can elaborate it out as much as you want to, and you can get to the bottom of all of this. Because ultimately, the issue with a lodial title is, in my personal opinion, one of the highest, if not the single highest, issue that we have to correct. Because if you don't own your lands, you're just a serf. And that's not what we are in America. In America, the people are sovereign. So with sovereignty should come a lodial title, which, as I stated, the original Wisconsin Constitution clearly lays out. So that's food for thought, and we'll talk about that later, probably during a brainstorming class or open roundtable on Wednesday. We can flesh out some more of these ideas, but I just wanted to bring that up, make sure that to show you here that even the civil grand jury manual, this is what they're allowed. This is some of the powers of the grand jury. Well, in a 25-member grand jury, then you can certainly do this, and you can go a lot farther and a lot deeper. Okay, so on to 921, next one. Access to public prisons and public records. The grand jury is entitled to free access at all reasonable times to the public prisons and to the examination without charge of all public records within the county. So, does the grand jury have the capacity to look into every single man and woman that's ever been put into any county prison. Absolutely. What should that process entail? That process should entail getting the records, the court records, of everyone who has been charged with some commercial crime that's sitting in some jail, and then immediately find out if there's been a warrant of commitment created. If there's been no warrant of commitment created, and if there's been no indictment brought by a 25-member grand jury of the peerage, then what the 25-member grand jury of the peerage should do is to discharge all charges against anyone sitting in any of these private for-profit prisons and jails, and also demand the full accounting on the private side of the court case regarding the bonds. Now, at the Vocational Science of Freedom, we have figured out a way to access the bonds on a court case. Now, if you cancel the bond on a court case, and this is going out to everyone who's currently has a court case going on right now. I didn't mention this the other day because it skipped my mind, but to get into the commercial side of these corporate courts, it's imperative to understand how the bonding works, because what happens is that when they create a court case and they charge your estate, which is the all capital letters name on your birth certificate, what they'll do is they'll usually create a constructive trust out of it, meaning in the court case itself. And that will usually consist of the first name, middle initial, last name, all capital letters. So that's the constructive trust that they create. So if you have a trust, and here's the thing, and this goes for any trust, not just specifically a court case, but any trust whatsoever. A trust has to derive its res, meaning the property and the stuff, from somewhere. So what they're doing in these private for-profit courts, as best as I've come to understand it from all these long years of learning exactly what they are doing, is that they charge the estate with a commercial crime. You come forward unknowingly and act as the trustee of the estate, not coming forward as the executor and the heir, but just as the trustee because you agree to be under the statutes or whatever, any other way that the court ends up basically finagling jurisdiction unto themselves. Then what happens is that the court case gets bonded. Now, why do they have to bond the court case? Because they don't own the property. And they're pretending like they don't know who owns the property. They're pretending like they don't know where the sole lawful heir is. And they're also, for sure, not allowing or not stating anywhere that there is a lawful executor that has been, or executrix, as the case may be with a female, that a lawful executor or executrix has been appointed for the estate, because then that would remove their administration of the estate. Because if you look around, I mean, they always talk about, well, we're just administering justice, right? You hear that term all the time. Okay. What they're doing is they're administering the aspect of the estate, but they have to trick you into being the trustee for it, so that then the administrator can tell you, the trustee, what to do, like go to jail, and to take a benefit and a privilege from them, because they consider going to jail to be a benefit. You get free room and board, right? We get to feed you. Yeah, free medical care. They consider that a benefit. So they have to bond the case because they don't own the property, meaning you, the physical, you, the body, because the body, your body, is part of that res that they're taking from the estate and putting it into a constructive trust. Okay, now the point about the bonds is this: we've figured out how to put in a properly worded state Open Records Request Act, sometimes called state FOIA, but technically the term FOIA is a federal thing. A lot of the states call them sunshine laws or open records laws. So anyway, you find your open records law or your state FOIA for your state. Then what you do is you use our template and you file this to the court clerk. Now, Do you always have to serve it on the court clerk? No, not usually. Usually, if you just simply mail a open records request act to directly to the, the court clerk that's actually elected, meaning who's ever holding the office position in the county, usually you don't have a problem getting the court bond information. And when you do get the court bond information, all you have to do is contact the bonding company, because the bonding company information will be on the information that they give back to you, because it'll be on the bond. The other interesting thing you're going to see is that the Bar Association takes power of attorney over you. Well, where in the hell did they get the authority to do that? Well, because you've come in as a trustee somewhere, and you've basically agreed by what's called tacit procuration, which is another way of saying assumed power of attorney. So by tacit procuration, they put you under power of attorney. And you'll see it right in the bonding information. And we have that, and there are gentlemen that have already done this and have agreed to share the bonding information. And so it's available to Vocational Science Freedom members. But it's not something I'm going to put out completely over the internet. I do want to keep it at least within our group. But it's accessible to anyone who wants the information and the templates. The templates are offered on the Vocational Science of Freedom price sheet, which is located on the Vocational Science of Freedom Gilded server under the VSOF information, under membership and prices. And just to make a note here, in case you're listening online, if you'd like to join the Vocational Science of Freedom Gilded server, you can do so by either the GAB group of the Vocational Science of Freedom, which is GAB group 30721, and you can find the Gilded invite over here on the right hand side of the screen. It's just gilded.gg/VSOF. And then you will, and it's better if you download the Gilded app or the application, so that you're not just running it on your browser. And then you can hit apply. When you get here, you can hit apply up here. And so there's two things you'll see up here. It'll say follow or apply. Please hit apply, and then you can fill out the questionnaire, and your application will be reviewed in the order of which it was received. And then you can join us here in all these fun talks and have access to all the various different class docs and information that are on the server. So to get back to the bond. So when you get the bonding information from them, it'll have the bonding company, and it'll have the name on it. It'll have either the constructive trust name or the estate name. And so what you do then is you contact the bonding company. Now, there was a guy a while back who, and this is a gentleman who I know personally, who was going to court for a traffic ticket. And he got there kind of early at court. And he was wandering through the halls, just kind of waiting. And he noticed this Rolodex sitting out in the hallway. And it had the date on it for that day's date. It had today's date on it. So he looked at it and he saw that his name was on a folder there. You know, one of these big 3-ring binder folders, and it had his name on it and the case number. So he looked around, looked down the hallway. There was nobody around. He picked up the folder and he went into the bathroom. He pulled out the bonding information and he took pictures of it with his phone. Then he came back and gingerly put the folder right back where it was. And then about 10 minutes later, a clerk comes out and rolls the thing into the courtroom. So what he did is he contacted the bonding company and he said, "Hey, do you have a bond with this number?" And they're like, "Yeah." "Is it in this name?" And they're like, "Yeah." "Who are you?" "Well, I'm that man. I'd like to cancel the bond." And they said, "Okay." So he canceled the bond on the court case. Now, what he did was he contacted the district attorney and he said, "Yeah, I've canceled the bond on the court case." District attorney, either out of ignorance or whatever, didn't believe him. So he goes into the next court hearing, which was, a preliminary hearing of some sort, whatever. And he says to the judge, he said, "Your Honor, the bond on this case has been canceled." And the judge looked at him kind of incredulously, like, "Really?" And he said, "Yes, Your Honor." And then the judge turned to the district attorney and said, "Is this true?" And the district attorney said something like, well, Your Honor, yeah, he said something like that, and blah, blah, blah. But he tried to slough it off, right? The judge picked up the gavel, slammed it down, and said, case dismissed. Counsel, in my chambers now. And there were like 10 other people waiting to have court that day. And that was the other thing he said. He said, counsel, in my chambers now, and bring your checkbook. So he knew the second that he had canceled the bond, he had canceled the case. But the trouble is that the outstanding charges still have to be paid, right? So if you can't take it out of the bond from a standpoint of a promise to pay, then guess who has to pay it? The fucking attorney. That's why they have to bring their checkbooks to every single time they come to court, in case they can't transfer that trusteeship, or in this case, where the whole thing gets canceled because the bond got canceled. Now, from our understanding, there's 3 different kinds of bonds. Now, looking over the bonding information that we've obtained from various different people that have done this, it doesn't, I can't find the specific terms of which bond it is, but supposedly there's a performance bond, a surety bond, and performance bond, surety bond, and I forget what the last one is. There's another name for the last one. And supposedly there are 3 separate bonds on each court case. But the point is that the information for the bonding company to cancel the bond is on the private side of the court case. And you see, here's the thing. That it just proves that there's a public and private side to every court case. Because when you go look up your case, you flip through that information, you don't see the bonding information in there. It's kept in a separate folder. So go get it and then cancel the bond, and then inform the judge that you've canceled the bond, and watch how fast he turns around. Because this has absolutely nothing to do with law. All of this is banking and merchant affairs. All of it. That's how everything runs in all these courts. It has zero anything to do with actual law, meaning natural law or common law or public law, meaning a harm. Nothing. Even the things that do have harms with them, like murder, they're still considered to be commercial crimes. Because all crimes are commercial, as it's clearly stated in various different sections of the Federal Code of Regulations. So yeah, if you need the information as how to cancel the court case regarding obtaining the bonding information, just go ahead and contact me, and I'll get it to you. So, okay, so to continue, back to our grand jury manual here. Okay, so let's go to section 922. Oh, there's one other thing I want to cover regarding the jails. Okay, so under this section, regarding looking at people that are in the prisons and to the examination. Okay, if you find anyone that doesn't have a warrant of commitment or doesn't have an indictment against them in the court file, I mean, you don't give these assholes any chance to just, oh yeah, it was sitting in the district attorney's office. No, it wasn't in the court file. Therefore, if it's not in the court file, that means the detainment of that man or woman in that jail is unlawful. And then the grand jury can simply, like I said, dismiss the charges and demand that they be free, simply for the fact that there is no warrant of commitment. And the grand jury could go so far as to find out how they got into that jail or prison, and then indict those who failed that man or woman in due process. They could go that far if they wanted to. Okay, so that's all I got to say about that. Okay, so now on to 922 here. Proceedings for removal of district, county, or city officers. The powers and duties of the grand jury in connection with proceedings for the removal of district, county, or city officers are prescribed in Article 3, commencing with Section 3060, Chapter, Division, blah, 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 Government Code. Okay, that's all Government Code stuff. You don't have to worry about that. You just negate that. The simple fact that you can look into it is the point. And when a 25-member grand jury of the peerage gets together, they don't have to follow the statutes, acts, ordinances, or codes of Roman civil law. They can just do it from the standpoint that they are the absolute power as the 4th branch of government, acting in their sovereign capacity to do so. But You get a district attorney that's corrupt, get rid of them. You get a county commissioner that's corrupt, get rid of them. City councilman, city alderman, all of it. Anybody. Find a problem, remove them. Plain and simple. And how do you remove them? You do a full proper investigation, you gather all the information, and you bring a true bill of indictment. And if the district attorney won't indict, then turn around and indict him too. And have the foreman do the prosecution, which, as I've stated before in past classes, has been done. The foreman himself can prosecute. In fact, all of you can prosecute a common law crime. And if you go back English jurisprudence, that was exactly how it was always done. Each and every man prosecuted his own case. There wasn't any of this district attorney, attorney general garbage. Everybody knew what, they had their own court. If you were a free man, you could not be denied your own court, which is clearly stated in the Magna Carta. And we, not just being free men, but also being sovereign, we can form a court of record, which proceeds according to the course of the common law, of which the tribunal is independent of the magistrate. So, just remember that. Okay, to continue. 923, investigation of matters of criminal nature presented by Attorney General. Whenever the Attorney General considers the public interest requires, he may, with or without the concurrence of the district attorney, direct the grand jury to convene for the investigation and consideration of such matters of a criminal nature as he desires to submit to it. That's true. And just because he's doing the exact same thing that anybody walking off the street would be doing. Any one of the people can walk in and give the grand jury that same information of their own volition, obviously, because they don't have to have concurrence with the district attorney either. So, he may take full charge of the presentation of such matters to the grand jury, issue subpoenas, prepare indictments, and do all other things incident thereto, to the same extent as the district attorney may do. Also, to the same extent, I would say, that the entire grand jury can do, or that the foreman can do. Because, again, there's no rules here. This whole entire civil grand jury manual, as I read in the beginning, if you go back to class 1 and 2, they state in the beginning of this grand jury manual that these are suggestions. There are no rules with a 25-member grand jury. Sky's the limit as far as what you want to investigate, how you want to go about doing it. Now, should you follow due process? Obviously. Should you act like a bunch of tyrannical bastards hell-bent on destroying every single man and woman that, in government? No. You should wield your power with grace, understanding, with tact. Let's put it that way. Because you want to put on a good show. And plus, this country, where it is right now, being as close as it is to, I've ever seen it, to a second civil war, let's not go out of our way to be the one who lights the match. Let's put it that way. All right, 924. Willful disclosure of making of information or indictment, misdemeanor. This is just saying that you're not supposed to talk about what you're talking about in the grand jury, which makes sense. And same thing with the second one. Willful disclosure of evidence, statement of juror, vote, misdemeanor. So again, just be quiet. Do not go running off and telling everybody what's going on during the grand jury. Okay. Secrecy of deliberations and voting, court order for disclosure of testimony. Each grand juror shall keep secret whatever he himself or any other grand juror has said, or in what manner he or any other grand juror has voted on a matter before him. Any court may require a grand jury to disclose the testimony of a witness examined before the grand jury. That's fine. For the purpose of ascertaining whether it is consistent with that given by the witness before the court. Meaning, they said such and such before the grand. So you have a witness. You subpoena a witness, or they just come in on their own volition, right? So you swear in someone who gives testimony to the grand jury. Then the trial happens before the petit jury, and the guy changes his tune. He starts singing a different song. Well, then you can go back to what he said before the grand jury compared to what he's now saying. And if it doesn't match up, then obviously you've got an issue, right? So that's why this is in here. It's just saying that, yes, you can go look at the information as to what they stated as a witness before the grand jury, just to make sure that it matches up with what is stated in court when the trial happens. Privileges of a juror as to statements and vote. Exception in case of perjury. A grand juror cannot be questioned for anything he may say or any vote he may give in the grand jury relative to a matter legally pending before the jury, except for a perjury of which he may have been guilty in making an accusation or giving testimony to his fellow jurors. So that's an aspect of, yes, even though that you are a grand juror, you can end up getting yourself in trouble for making false accusations or giving false testimony to your fellow grand jurors. So just be aware of that. So if you have somebody who's a really real dingbat on the grand jury and they're overzealous and they just start lying about things, well, guess what? You can hold them to account too. Oh yeah, thank you, digital replevin. Yeah, I think that was the last type of bond. Thank you. Yeah, replevin bond. So bid bond, performance bond, replevin. Yep, those are the three. Thank you. Okay, 924 here, or 924.4. Furnishing succeeding grand jury with information or evidence, exception. Notwithstanding the provisions of such and such sections, any grand jury, or if the grand jury is no longer impaneled, the presiding or sole judge of the Superior Court may pass on and provide the succeeding grand jury with any records, information, or evidence acquired by the grand jury during the course of any investigation conducted by it during its term of service, except any information or evidence that relates to a criminal investigation or that could form all or part of the basis for issuance of an indictment. Transcripts of testimony reported during any session of the grand jury shall be made available to the succeeding grand jury upon its request. So, what is that basically just saying? It's basically saying that the records of the grand jury are perpetual. They go from one grand jury to the next, to the next, to the next. So they're always available. Indictment not returned, court order for disclosure of testimony of witness. If no indictment is returned, the court that impaneled the grand jury shall, upon application of either party, order disclose of all or part of the testimony of a witness before a grand jury to a defendant and the prosecutor in connection with any pending or subsequent criminal proceeding before any court if the court finds following in an in-camera hearing, which shall include the court's review of the grand jury's testimony, that the testimony is relevant and appears to be admissible. So that's just making sure that if no indictment is returned, what they're to do with the record of the various different things that happen in front of the grand jury. Okay, Article 2. This is page 88. Investigation of county, city, and district affairs. Section so-and-so sections. So let's just get into the sections. I'm not going to read that beforehand. Accounts and records of county officers, report and recommendations. The grand jury shall investigate and report on the operations accounts and records of the officers, departments, or functions of the county, including those operations accounts and records of any special legislative district or other district in the county created pursuant to state law for which the officers of the county are serving in their ex officio capacity as officers of the districts. The investigations may be conducted on some selective basis each year, but the grand jury shall not duplicate any examination of financial statements which has been performed by or for the Board of Supervisors. Yeah, well, that whole thing about the Board of Supervisors, we talked about this before, so I'm not going to rehash this, but apparently, at least in California, they have this Board of Supervisors, which is really the kind of the masters of the county, that they have all of these little weird provisions in this grand jury manual talking about, well, you have to give it to the Board of Supervisors, and oh, you can't go against the Board of Supervisors, and only the Board of Supervisors may do such and such. Well, what is that telling you? It's showing you that they're treating you like an infant. So, just to make that point. Okay, cities and joint agencies, examination, investigation, or report upon fiscal matters or needs. The grand jury may at any time examine the books and records of any incorporated city or joint powers agency located in the county. In addition to any other investigatory powers granted by this chapter, the grand jury may investigate and report upon the operations, accounts, and records of the officers, departments, functions, and the method or system of performing the duties of any such city or joint powers agency, and make such recommendations as it may deem proper and fit. So, can you get any records you want? Yes. Can you look into any department you want? Yes. Can you look into the functioning of that department? Yes. So it's telling you, you can tear everything apart if you want to and get to the very bottom of either graft, corruption, single penny missing. Doesn't matter. You can do it. All right, I'm going to skip the next two. Expert and assistants, employment, compensation, auditors, and appraisers employed in examination of records. If, in the judgment of the grand jury, the services of one or more experts are necessary for the purposes of yada yada, or any of them, the grand jury may employ one or more experts at an agreed compensation to be first approved by the court. Now, again, you don't have to worry about approval from the court to do this if you're a 25-member grand jury of the peerage because you're above the court. Now, here's the thing. I just want to make this point. The grand jury is still an arm of the court. So I didn't want to misconstrue that. So make sure that you understand that. So, but what court? Well, the superior court of record, because it has to be, if you're going to convene a common law grand jury, you're not going to convene a common law grand jury of 25 members of the peerage by opening up a maritime admiralty court. Okay. So your jurisdiction has to mesh with what you're doing. So, and I was having this discussion today with a gentleman when I was also talking about the bonds and what else we can do with the grand jury. I said, basically from the grand jury being an arm and an instrumentality of the court, that when one of us, as one of the people of a particular state, says, hey, I'm going to convene a court of record, then that sovereign says, I think I need 25 other sovereigns to really look into this before, I go and start filing suits against people. I think there should be more investigation to happen. Right? So technically, this is how this is supposed to work in our American jurisprudence of us all being sovereign. One sovereign says, hey, I've got a problem. He convenes his court of record, and then he says, I'm going to convene a grand jury of 25 members of the peerage from my court. He does so, brings it forward. They start investigating. They do subpoenas, they do this, they do that. Maybe they bring an indictment, so on and so forth, right? Then the indictment goes through, or the recommendations go through, or the investigation happens. And that's the way that one sovereign calls on 25 others to come fix a problem. All of the grand juries that are out here, save the grand juries that are actually being run by 25 members of the peerage, all the grand juries that are out here are all being convened under inferior courts. They're not being convened under superior courts of record that proceed according to the course of the common law. So that's your first inclination that, one, we need to have our courts of record up and running. Two, we need to understand how to establish them. And three, we should have a simple little process to say, hey, I think I need 25 other men around me. Would there be any limitation for us to do that? The answer is no. Has it been done like that in the past? I would say yes, it would have to have been, because as I said, you go back into English jurisprudence and you see where everyone was their own prosecutor. Well, they still had grand juries back then. So where'd they come from? Well, they had to have come from someone who had convened a court of record. So and this is the kind of raw reason that you have to be able to implement to do what we're doing and to find the solutions for all these immense amount of problems that we have going on at the moment. So anyway, let's continue. Okay, so the experts and assistants, so they can hire their own assistants and experts, so on and so forth. Now, just to make a note here, and they might say it later, but I'm just going to dovetail this in, that you can hire your own investigators as well. If a grand jury has a bunch of corrupt law enforcement around them, meaning corrupt police chief or sheriff or whatnot, then who will not, when asked to help the grand jury, will not perform their duties properly, well, then the grand jury can go and hire their own investigators to do and investigate whatever they want to have done and whatever they want to have investigated. Is there any rule that says you can't do that? No. In fact, that's been done in the past, as I mentioned before, with a grand jury in Minneapolis, St. Paul, which I won't rehash, but you can, if you've gotten this far and you've listened to all of the grand jury sessions, you will have already remembered the story. So I'm not going to go back over that again. But yes, you can employ your own investigators, and you should, particularly when the ones that are around you are not doing their job. Okay, so, and then just gets into other aspects of payment and whatnot, and just to make sure that the people that you're hiring obviously get paid. So, okay, let's move on to page 92. Salaries of county elected officials reports. Yep, you can do a report on the entire salaries of anybody in the county. Needs of county officers reports, including abolition or creation of offices and equipment for. So, guess what? The grand jury can create or abolish an office. Now, can they go about abolishing a constitutional office? I would say the answer to that is no, because you can't have a grand jury going and altering a state constitution all willy-nilly without going through the proper processes of how one would amend a state constitution. So you can't do that. But at the same time, there's a lot of offices running around out here in the counties and in these municipalities that have nothing to do with the Constitution at all, meaning they're all under Roman civil law, clearly. So, if you get just abolish the office, just get rid of them. Okay. Public release of grand jury reporting containing unprivileged material and findings. I'll skip that. This is just an aspect of running the grand jury in secret. Comments and reports upon persons not indicted. So, if any grand jury shall in report above mentioned comment on any person or official who has not been indicted by such grand jury, such comments shall not be deemed to be privileged. Oh, okay. So basically what that means is that if you've had a bunch of discussions about how good this guy was and that nope, we didn't indict him because he was a great guy, then they shall not be deemed to be privileged. So basically that means you can put that information out and put it in reports. Now you shouldn't talk about it prior to the vote on the true bill. Let's not do that, but you get the point. Payment of expenses, again, just make sure everybody gets paid. Order directing district attorney to institute actions for recovery of money due county. This is where I was talking about that they're using the civil grand jury basically as a debt collection agency, to not put too fine a point on it. Comments and reports on grand jury recommendations. This is how you're going to do your reports as to what you recommend they do for certain various different things. I'm not going to get into this because we covered it in the report section. Response to grand jury recommendations, content requirements, personal appearance by responding party, grand jury report to affected agency. Yeah, this is where it gets into the back and forth between when you're talking to an agency and what you suggest that they do, and they talk back with the grand jury, and you figure out what needs to be implemented and what time frame and so on and so forth. So I'm not going to read all that either. Examination of books and records of Redevelopment Agency, Housing Authority, and Joint Powers Agency. Those are just some specific things about those agencies, which I won't get into. Books and records of special purpose assignment, taxing district. Again, this is to get into the tax. So basically, the understanding of getting into the taxing district is that you guys can look into what? How the county taxes anything. So there's all of these various different taxes that these county corporations put on people for services, of which a vast majority of them either one, never use, or two, never asked to pay for. So why are we paying for things that we didn't ask to pay for? And not to make too fine a point on it, where's the contract? Where's the contract between me and the county that says that I'll pay for so-and-so and so-and-so and so-and-so's retirement fund? I'm not getting any use out of that. It doesn't help me in one way, shape, or form at all. And probably, at least in some of the cases, the people whose retirement I'm paying, I don't want to even exist in the county. So, again, that's going to be one of these detailed things where you really get down to brass tacks as to, who's taxing what as far as the property tax is concerned, and where do you get the authority? I just start there, because all lands are allodial, at least in Wisconsin and Oregon, but meaning that you can superimpose that on all the rest of the states as well. And I'm quite certain that Texas has some aspect of that in their constitution as well. But the point is that under the equal footing doctrine of the federal constitution, what one of the people has as far as a right is concerned in one state, then a people in another state have that as well. Because rights are expansive. They're always meant to grow in scope. not to diminish. And that's an important part of it's important understanding of American jurisprudence as a whole, that our natural law rights should always expand, not ever go backwards and contract. So to continue, examination of operations for nonprofit corporation established by or operated on behalf of public entity. Yeah, like say the judge's 501c3 slush funds. Let's look into that for a couple years. Anyway, Article 3, legal and other assistance for grand juries. So I'll skip the thing and just get into it. Advice, well, actually, you know what? I'll check and see if we need to read any of these, and then we'll just skip past all of it. Advice from judge, district attorney, or counsel. Fine, you can give advice, but you don't have to listen to them. Appearance of district attorney, you can throw him out if you want to. I already know that. Special counsel and investigators. Yeah, those would be people that you'd be doing special investigations in the grand jury, or if someone's appointed a special counsel to take care of a matter. And see, here's the thing: that term, special counsel, we hear it all the time in federal cases about, oh, someone's been appointed a special counsel. All that means is that they're prosecuting the case. So when we do that, guess what? We're special counsel as well, because there's no license to practice law, doesn't exist. So when we choose to convene our court of record and prosecute a case and or investigate through a grand jury, guess what? We can do that as special counsel. Sacramento County retention of special counsel for grand jury, interpreter, subpoena, competition, stenograph. Okay, the subpoena part might be interesting. Let's skip to that. Okay, interpreter, subpoena, competition. The grand jury or district attorney may require by subpoena the attendance of any person before the grand jury as an. Oh, that's what it is. Okay, so they can subpoena an interpreter. Okay, got it. While his services are necessary, such interpreter may be present at the examination of witnesses for the grand jury. Okay, great. All right, so that's all that was. Transcripts of testimony. You guys, like I said in previous class, record everything. Just, we live in a digital age, just audio, video, all of it. Payment of reporter affidavit for preparing any transcript in any case pursuant to, well, you know what? If you have an audio recording and it's clear, you don't need a court reporter anymore. There are literally computer programs that you'd simply play the tape, and guess what? It types it out for you. Now, should there be somebody overseeing it to make sure that there isn't some typo or that the word isn't stated incorrectly? Sure. But a member of the grand jury can do that. We don't have to pay any court reporter anything anymore. And furthermore, I've seen so many court reporters place into the record incorrect statements or not give the full account of what actually happened so many times that I simply don't trust I don't trust any of them anymore. Period. So anyway, services charged against county services. Okay, again, stenographer. All right. Meeting room and other support. The Superior Court, right, Superior Court of Record, shall arrange for a suitable meeting room and other support as the court determines is necessary for the grand jury. Well, no, as the grand jury determines is necessary for the grand jury. Any costs incurred by the court as a result of this section shall be absorbed by the court or the county from existing resources. So guess what? Grand jury needs something, county can pay for it. That's basically what that says. Article 4, conduct of investigations. Okay. This will be a fun part as far as getting into the investigation. So I think I'll pause here, make a note, just highlight this so we know we'll come back to this. And now I want to open up for the last couple minutes here. I want to open up and show you guys that letter from the foreman to the judge. Okay, so this is in 2014. Judge Cynthia, but I'm not even going to try to pronounce that, from the grand jury foreman, Dixie County grand jury meeting, so on and so forth. Your Honor, I'm afraid we have some very serious problems. Just to refresh your memory, I would first like to review with you a very important Supreme Court case, USA versus Williams, which is the one that I always make sure that people know about. Then I will explain in detail the dimensions of the problems we face and the best solution I can think to remedy this ugly situation I believe Mr. Stigmeister has put us in. Now, I don't know if that's got the actual name, but I mean, my God, talk about somebody that would be a shisty fool. Anyway, I need to remind you that I'm under two oaths to our Constitution, which I take very seriously, and I trust this is a confidential discussion between us. Well, at least until this letter got sent out. Background. As foreman, I have been frustrated in every effort to bring before the jury a matter of the utmost urgency and concern. Now, why would you be having a problem, right? Dealing with fraud and corruption within and among a number of our public offices. Okay, now remember last time, and I'm not gonna get into this, but remember when we talked and looked up and read this grand jury report from California regarding the causes of municipal corruption in San Francisco, and we read this part of it, right? Okay, so this is what this report is more or less what this guy is trying to get done, or it certainly sounds like what he's trying to get done. Okay, no, because the information I have involves crimes also affecting surrounding counties, it is my duty to reach out to those jurisdictions, which it would be. If you have matters that go outside your county, contact the next counties over grand jury and say, hey, we've got issues that cross jurisdiction here. You guys need to know about it. I'd be like, great, wonderful. What are they, right? You guys can take care of it together. I directly contacted Levy and Gilchrist County Clerks of Court on or about July 28th, requesting they give me contact information of the grand jury forepersons of their respective counties, and asked them to contact me on a matter of official business. I received no response from either county's clerk or grand jury foreman. You want to know why? Because the clerks didn't pass it on. They went and asked the district attorney if they should, and I'm sure the district attorney said, no, don't do that. Why? Because it calls the power of the grand jury. I can guarantee you that's what happened. So, but interesting, he puts in the grand jury instructions. He's telling the judge, "Hey, look, grand juries has a duty to cooperate with any other grand jury investigations being conducted in this county or elsewhere." Right? So he's making the point, right? I am in possession of a complaint concerning a subject of which our state attorney, Mr. Jeffrey Stigmeister, has been aware of for some time, yet has failed to act. Surprise, surprise. It is my sworn duty as a member of the grand jury to make this matter known to my fellow jurors so that they may evaluate its validity and issue a true bill, if they deem it appropriate. Not being familiar with the process, I went to the clerk of court, Dana Johnson, on July 21st and requested she schedule a session of the grand jury, see attached hand-delivered letter. I received no immediate response. The following day, I returned to Mrs. Johnson's office and inquired as to the status of my request. She informed me, instead of handling the arrangements within her office, she had forwarded the request to Mr. Stigmeister. Right. See, what they do is they always go to the filthy attorney. But anyway, and he will be calling me the next day, the 23rd. Late in the afternoon, 23rd, I received Mr. Stigmeister's call, and he informed me that he would notify the jurors by mail of their need to appear at the first opportunity. I further suggested, in order to avoid wasting the jurors' time and the county's money, it would be very important he include in his notice a copy of the jury instructions, the grand jury handbook, and the U.S. Constitution, along with a simple instruction to please read and understand the documents with a reminder the proceedings must remain secret. I emailed him a letter to be included with the above items. See attached. Mr. Stigmeister sent out a notification along with jury instructions and handbook, omitting the Constitution in my instructions. Wonder why. Mr. Johnson's office also mailed out an official notice to jurors on July 30th. I went to Mr. Johnson's office and requested several items. To see the room which we would be meeting, to use the copier services for jury materials, determine if there was a budget, as handbill indicates. List of jurors, names, and contact info. Inquire about the procedure if less than a quorum. After viewing the courtroom, I voiced my concern over the recording equipment and the potential conflict with requiring the proceedings to be secret. She assured me no other room in the courthouse could hold 20 people. Right. But since I was still concerned, she committed to have the microphones turned off. Right. Because all these courtrooms are wired now. So what are they going to do? They're just going to listen to the district attorney and the judges, and everybody's going to listen to what the grand jury is doing until, or unless, you guys turn it off. or you have your own audio video recording equipment, which is what I suggest you do. So it's still recorded, but guess what? They don't get to see it. So to continue, Miss Johnson told me there is no budget for the grand jury. Bullshit. I could use the copier at the commissioner's office, and she would get me a copy of the jurors list. She also added she wasn't aware of any procedure for dealing with less than a quorum. Really? Referring me to the state's attorney for information. Well, the hell with the state attorney. The information's there. I mean, clearly we're reading out of a grand jury manual for the last several weeks, and there's dozens of them on archive.org. So the stupid clerk can't say to a grand jury foreman that they're not aware of a procedure for dealing with less than a quorum. Absolute lies. On the 31st, I still had not received the jury list and inquired again, receiving nothing but excuses and no results. See where this is going? On the morning of the grand jury session, I arrived at the courthouse and began preparations for the meeting. Miss Johnson was not in her office on Friday, but I was told I could reach her on her cell if I had any concerns. I told the clerk it was imperative I have the jury list so I would know who was supposed to be there and verify identities. No one seemed to know what was going on. Of course not, because these people do not want a grand jury actually, especially not a 25-member grand jury. The peerage would. As far as I'm concerned, this Mr. Stigmeister, he would have done this to any common law grand jury. He would have been thrown in jail for at least 2 weeks for contempt of the grand jury. Oh, you want to mess with us? Fine, you can go sit in jail for a while. Think it over. Moron. So, about 12:30, Mr. Stigmeyer walked out of the sheriff's office as I was passing by and told me he would be with me in a minute. I walked to courtroom A, and he was already there with a deputy talking with him about the microphones and setting up the courtroom for the session. I noticed the microphones were still turned on. I asked Mr. Stigmeister for the jury list, and he told me it would be inappropriate for me to know the jurors' names. Huh? I asked how was I supposed to know who was present, and he told me he would handle it. Again, you get a cocky son of a bitch like this, go throw him in jail for a couple weeks, see if his attitude changes. Hold him in contempt of the grand jury. He said he was concerned whether we have a quorum because he knew 3 jurors would definitely not be able to attend. I asked him, he knew? He said, how he knew? Because he said, I called them all. Okay, asshole. Where's the information then? You have all of their names and numbers? No. I'm the grand jury foreman. That's my information, not yours. He also told me my vice foreman and clerk would not be there. I told him I wasn't aware I even had a clerk, as it is stipulated in the instructions. The clerk is to be appointed as a first matter of business in the initial meeting. He said he only knew I had a clerk who wouldn't be there. A woman walked in the courtroom and greeted Mr. Stigmeister. I asked who she was. He replied, she was his court reporter. He had worked with her for 20 years, and he vouched for her. Uh-huh. I told him according to the instructions, the decision to have a reporter was up to the jury. He stated this was his jury, and he had made the decision. I responded, this was the people's jury, and it is independent of the court and the state attorney. He agreed it was independent, but he was statutorily responsible for it. No, not... Okay, there's the point right there. He agreed it was independent, but he was statutorily responsible for it. He's its daddy when you have a bunch of infants not knowing what they're doing. Get it? I asked if he was in charge. If he was in charge, why was I there? His response, I wonder that myself. I mean, the hubris of that shit is off the charts. As the jurors came into the courtroom, State Attorney Jeff Stigmeister greeted them, and when a quorum was filled, he directed them to the jury box, placing them in the context of a regular court setting. I was uncomfortable with the seating arrangement, as it established a mindset contrary to a more casual forum for open discussion, which is exactly what the grand jury can do. After a couple of opening remarks and notifying them the court-appointed vice foreperson and clerk were absent, he turned the proceeding over to me. I asked him if the jury could be left alone to proceed with the matters at hand. He told me firmly he, his assistant bailiff, and court reporter were required to be present. And he was not leaving. He further showed me from the grand jury instructions. The state attorney or statewide prosecutor and assistant are your legal advisors on all matters that come before the grand jury. It is your duty to give weight and careful consideration to this advice. The state attorney or other statewide prosecutor or assistant shall be present at all times when you are making investigations and will interrogate the witness and administer necessary oaths. Does that say anything about deliberation? No. But again, this is a filthy statute. This has nothing to do with a common law grand jury of 25 members of the peerage. So, I pointed out there was no investigations being done at this time. No witnesses to be interrogated and no oaths to be administered. He refused to leave. Again, that's when I call the bailiff and arrest him. Or I call the sheriff and say, get this asshole out of my jury room. There was a bailiff present as the jury took their seats in the jury box. The court reporter took her seat at the table and began taking shorthand notes, a voice recorder on the table beside her. 4 armed deputies stood outside the door to the courtroom, in view of the jurors. As a complete non sequitur, Mr. Stigmeister made the comment before the jury. I had even tried to contact juries in neighboring counties and asked me to remind him which counties they were. I told him Levy and Gilchrist. His query was unexpected, and being disconnected from the subject presented, it seemed to be made as an attempt to throw me off subject and to let me know how he was in control. I suddenly realized this was not a grand jury, but a sham orchestrated by Mr. Stigmeister. Exactly, which is what every single one of them is. Now, I will leave the rest of this fun reading for all of you guys. I'll just make a little mark here, and I'll save it in the grand jury manual so you guys can know where to come read this. You guys can read the rest of this letter yourself. It gets more and more interesting. But seeing as we're coming up to about an hour, I will let you guys have fun with it, okay? But you will fully understand the difference and why we have to take back control of our grand juries. So, with that fun stuff being said, next Saturday, we'll come back to the conduct of investigations, about how we can investigate such and so forth. Feel free to read the rest of the grand jury report if you want to from California. It's 68 pages. But juxtapose this report, which was done in, I believe, 1908. So juxtapose this report of the grand jury compared to what this gentleman, this 4-person, had to deal with this asshole. And really think about that. Between how much has changed between then and now. Okay? So, with that, I will cut this off for the night, and I'll take questions off air. And so I thank everybody for showing up. And tonight's been Vocational Science of Freedom, Saturday night Civics and Sovereignty class, of which we've been covering the California Grand Jury.